We have breaking news, as we mentioned, could happen at any moment. Trump has just requested a stay before the Supreme Court of the federal election case. Lisa Rubin is back with us and reading this as we get it. So you've had about a minute and a half. What have you processed in that time?
You know, one of the things I think it's important for our viewers to understand is the standard for granting a stay.
Sure.
And in order to get a stay, as opposed to substantively asking for Supreme Court review, you have to show that there would be irreparable harm to you, meaning harm that no money could compensate you for, that you would be harmed by just the very act of this case moving forward. The arguments that Trump is trying to make here with respect to the stay aren't just about him, but I notice that he is arguing that his supporters would have their First Amendment rights violated by the fact that he would go to trial. And I'm confused by that because no one is saying that the trial of former President Trump would preclude people from voting for him. No one is even saying that a conviction of former President Trump on the charges here would preclude voters from choosing him in the upcoming presidential primaries or even in a general election. So one thing that I'm really eager to do is to dig into this argument of how his legal team is conceptualizing the First Amendment damage to his supporters from the very fact that he could stand trial in the next months.
Given that we now have this in hand, and granted, we've done a cursory reading of it.
At best.
At best. I'm nothing, you are nothing, if not a quick study. The audience here, of course, is the justices and their clerks. I get that broadly.
Yes.
But I wonder, as you craft an argument like this, especially given that there may be some surprises in the way that this was crafted, are you strategic about which justices you believe that you are messaging to?
I think you are. And I'll give you a couple that I think people... One of the reasons... Let me step back for a second.
Sure.
One of the reasons there's wide disagreement on what could happen here, everything from the scenario that Andrew was laying out for you about how much time the justices could take in terms of kicking this out until October or beyond versus a very quick denial of the stay and allowing the case to go forward, is because there's some questions about how certain justices would behave here. And I think the biggest question mark for people that I talk to is Justice Kavanaugh. Justice Kavanaugh, prior to being appointed to the D.C. Circuit when he was 37 years old, sort of staggering to think about, was the White House staff secretary to former President George W. Bush. He holds the office of the presidency in extraordinarily high esteem. He reveres the White House and the executive office of the president. How that cuts here is something that's hard to understand. Is Justice Kavanaugh going to be a vote for presidents having some degree of criminal immunity? And is he still willing, notwithstanding that he would believe that some immunity is appropriate here, to nonetheless rule in this particular case that the allegations against Donald Trump, if taken as true, as the justices are obliged to do, are so beyond that outer limit that the case against him can go forward? I think he might.
I want to bring Andrew Weissmann back into this conversation. Andrew, Hotel California, check out You Never Leave. Here you are. I know you were reading this along with us, and our friend Lisa Rubin is desperate to actually do a deep dive into this. So I'm going to give her a minute to do just that. At first blush, what strikes you?
Two things. The first is the incredibly inappropriate first sentence.
This is deja vu all over again. Yes.
Citing Yogi Berra. You know, if you were going to be snarky, they might as well have cited Yogi Bear. I mean, that is just a bizarre way to start on something they are asking the Supreme Court. Remember, these are the lawyers for Donald Trump, where Donald Trump and his lawyers have said that their position is that the president of the United States can kill people. And as long as he hasn't been impeached successfully, that is impeached and convicted for it, he cannot be prosecuted. So that for something this serious, that is a bizarre, really bizarre first sentence. And so I think has a real tin ear. The second thing is that stressing this argument about I mean, they're sort of shifting, I think, a bit their theory, which is that all of the actions that are charged by Jack Smith are within the outer bounds of what a president can do. But the problem with that is that a very, very well-respected 11th Circuit judge, the chief judge, Judge Pryor, has rejected that in connection with a decision that Judge Pryor wrote in connection with Mark Meadows. So I don't think leading with that kind of argument after the first sentence is Yogi Berra, then going to an argument that you know that Judge Pryor has rejected. Both of those are not terribly, in my view, strong ways to start. But I should caveat that with, like you, I am sort of speed reading, and so that this is just my initial impression that it may be unfair to the full submission.
I promise I'm going to go back to Lisa Rubin in a second so that you can continue your speed reading, Andrew Weissmann. But I have a question about your initial analysis, which is why shift your argument here if you're Team Trump? Why take that tack now?
Well, the D.C. Circuit was a blowout. That the idea that you were sort of leading with this idea that you can have that you said to a judge that SEAL Team 6 could kill people on presidential order is one you have to have a better response. You have to have a better argument than that. And to be fair, it is often the case that as matters go up the chain to the Supreme Court or even from a district court to a court of appeals, that different lawyers or even the same lawyers will hone their argument and realize that they have better arguments that are more responsive to issues raised by the various judges as the case progresses. So in some ways, it's a sign of good lawyering that you are thinking about and trying to assess what the strengths and weaknesses are of your argument and how they could respond to various questions you would get from various justices or judges along the way.